morning. Welcome to the ceremonial sitting of the First District Court of Appeal. We got a nice full room today. That's very nice. We have 4 cases on the docket this morning. We are going to hear the first 2, and then we're going to take a break for some of these students are going to leave, and we're going to get another group of students. So our first case on the docket is Carolyn Banks versus Alachua County School Board. Counsel, are you ready?
Yes, sir.
You may proceed. And you have 15 minutes per side.
Thank you. Good morning. May it please the court. Eric Lindstrom on behalf of the appellant Carolyn Banks. I'll try to reserve 3 minutes for rebuttal. Ms. Banks is appealing the dismissal of her complaint with prejudice. So this court reviews the complaint to determine whether it's sufficient. In doing that, you have 3 issues before you. Whether the complaint states a cause of action for contract reformation based on unilateral mistake, whether the complaint states a cause of action for unlawful restraint of trade, and whether either of those claims is barred by the 5-year statute of limitations for enforcing a written contract.
Help us understand a little bit. You filed a complaint, there's a motion to dismiss, there's a hearing on the motion to dismiss, and here comes this order, and that's the end of the case.
There was a motion for sanctions as well.
I saw that in the file. Did you, at the hearing, we don't have the benefit of the transcript from the hearing, did you ask the trial judge to amend, leave to amend the complaint?
I don't remember whether we asked that or not. We don't have the benefit of the transcript, and the court's order is unfortunately, it doesn't explain why the court ordered. And I know that's one of the things that the appellee has complained about, that we don't have a very good record. But this case is the sufficiency of a complaint. So it falls or lives as a matter of law. One of the cases that we cited, the Goodall case, which is one of the Reformation cases, similarly didn't have any explanation for why the circuit court denied the Reformation claim in that action. So we think that your honors are able to review the complaint and apply the law as a matter of law and decide whether the complaint is sufficient. And it's de novo review, so we don't think that that's a problem.
So the contract you're seeking to reform is a 2008 contract.
Correct. The parties negotiated an employment discrimination settlement in 2008. During that settlement, during the time period when that negotiation was happening, the HR director for the school district called Ms. Banks into the HR director's office and presented Ms. Banks with this agreement on the back of which was a handwritten language drafted by the HR director herself. This meeting, I understand, was just the 2 of them, and the complaint alleges that it was outside the presence of Ms. Banks' attorney and outside the presence of Ms. Banks' union representative. During this meeting, the complaint alleges that the HR director misrepresented the agreement by saying that when you sign this agreement, you'll have to not work for the school district for 5 years, and Ms. Banks signed the agreement with that understanding. She then waited 5
Did she read what she was signing?
It's not in the complaint. That's going to be one of the factual questions about what were the circumstances of that meeting, whether Ms. Banks was negligent or not, and
don't we generally hold people responsible for the things they sign, whether they allege someone told them something inaccurate about it or not?
We do, Your Honor, but this court has several times confirmed that a cause of action for reformation exists. And each of those cases, the Nowak case, which is controlling in this district, the Ayers case before that, we've cited the Goodall case from the 4th DCA, all of those cases dealt with even more sophisticated parties contracting with each other. Those cases, even more than that, had in the contracts integration and merger clauses where the plaintiff said, I understand what this says, I understand I'm not relying on any outside agreements, and this court, in those cases, allowed those claims to go forward on the same theory.
Well, let's focus then on the statute of limitations
Right.
of this, and I know there's a debate as to whether that applies to a contract reformation claim, but we have held in the Silver Shells case that contract reformation is subject, at least under the facts of that case, to the 5-year statute of limitations. How do you distinguish that case?
I I'm not familiar with that case. We cited to the Corinthian case, which is directly on point from the second DCA, holding that reformation is not subject, that the statutory language on a contract means a breach of contract or enforcing a contract, but not changing a contract.
So Silver Shells is from the First District Court of Appeal, and it analogizes reformation of a contract to basically a breach of a contract, which would fall within the parameters of the 5-year statute of limitations.
And if that is the controlling law, I'm sorry for not citing it, our complaint, though, still would make out the equitable tolling doctrine for the same reason that we have contract reformation based on inequitable conduct and misrepresentation. We have equitable tolling under the controlling law by the Supreme Court, that those same elements establish equitable tolling. We also have the controlling law in this district that you can't bring a declaratory action until you have a live dispute. And so we've cited the Helfrich case, which is a pension plan dispute involving an ambiguous term in the pension plan. And this court held that a plan participant couldn't file that action until they actually applied for the benefit and were denied. And so the same thing I think would have happened in this case if Ms. Banks had tried to file a declaratory action prior to 2015 when she applied for work. You all would have said she doesn't have a case yet because she hasn't actually applied. So her claim didn't actually arise until 2015 when she applied. Even if there were a statute of limitations, it would have been told until that point, because that's when she first realized that the HR director was wrong or had lied. It's a question of fact, we don't know.
You would agree, going back to where we started, it's undisputed that your client signed this settlement agreement, correct?
Correct. She signed it, and I think it's fair to say that it says what it says. I don't think there's any dispute that as lawyers we can read that contract and it says what it says. But that, again, going back to the Reformation case.
Then I think probably as a school teacher you can read that contract that says what it says.
Well, but it's a question of fact. You know, when you are an individual asserting a claim where you're already being discriminated against by the school district, and you're called into your HR director's office by yourself, outside the presence of your attorney and outside the presence of your union representative, especially when we have a state law that says you cannot have an HR director negotiating with an individual in a union outside the presence of that union. That's a really vulnerable situation. And so she is, these are all questions of fact, though. These are the questions that the circuit court should, on remand, look at the actual circumstances here, to see how inequitable, how negligent, if she was negligent, how negligent was she? If the school district was inequitable, how inequitable was it?
That to the settlement agreement. Are you claiming anything about that is ambiguous? Anything about it is other than what's right in front of us?
Well, yeah, again, I think as attorneys, we can read that, and I think as attorneys, it says what it says, and I don't think we're not trying to say that it doesn't say what it says, but
and it says what it says.
Mm-hmm.
Your client has no recourse.
Well, but again, the Reformation cases talk specifically about plain language not being a defense to a contract reformation claim. Those cases, again, that had the integration and merger clauses, they said in plain language. So in the NOAC case, you all had a contract that said it was an insurance agent's contract, said it could be terminated for any reason, quote, for any reason, unquote. And the plaintiff said, well, actually, during negotiating that agreement, they said they would never terminate except for cause. And so this court allowed that plaintiff to proceed on a reformation theory based on the misrepresentation, allowed that plaintiff to proceed on that theory. Even though the plain language of the contract said what it said, there was a misrepresentation, and that's the nature of the cause of action for unilateral mistake. You
Let
could
me
all,
ask you about the mutual mistake, though, argument, because you seem to be alleging reformation based on mutual mistake and unilateral mistake. And so what are the allegations that would support that the school board intended something other than what's written in the settlement agreement?
we rely primarily on unilateral mistake. And I don't know whether there's actually a mutual mistake. That requires more questions of fact. We don't actually know what these people were intending at the time because we haven't had a chance to take any discovery. I don't know whether the HR director was lying or whether she actually herself believed that the contract would only prevent Ms. Banks from working for 5 years. Either it was a mutual mistake or it was a unilateral mistake. We've alleged unilateral mistake primarily.
So you allege essentially that your client had been told that she'd gotten the job, and then they found this handwritten
Yes, so-
thing in the file, and then took the job away from her.
Yes, and so in 2015, she applied with the principal. The principal, I think, told someone she's got the job, she had a good interview, and then I think the HR department in the downtown office found out and told her, no, you can't apply at that point. And not only can you not apply, you can't apply for the rest of your life. That's the circumstance.
But
Right?
the school board could have waived this agreement, right?
So that's one of the questions. That's one of the issues that I raised in the brief. That yes, the school board could renegotiate this, and so having the bar being that she can't even reapply sort of prevents her from even entering into the school district and trying to renegotiate this, because that would be reapplying. You know, if it were, I think we cited the Golden case in California, which is a single employer case, and I think in that case it just says that the employee will not be authorized to work, or something. I forget the language, but it was a no rehire, not a no reapply. So this case is even more pernicious because Ms. Banks is prevented from even going into the school district and talking about a job. She can't even apply for a job to get the process started.
Is the no rehire provision as broad as in the case that you cited? I'm assuming she's free to apply to a charter school, but just not something within the district.
Right, so under the restraint of trade analysis, there should have been a factual consideration about how burdensome actually is this contract. Is it truly a material restraint? And that's going to be a question of fact. The Golden case was very factually intensive, but that case found that a very large employer can be a restraint of trade for someone's profession when that employer is so big that it actually prevents someone from engaging in material economic
Yeah, but
activity.
is one county school board that? You know, because you got privates, you got charters, you got other counties that are nearby, you know, counties in Florida are not that big.
You're right, Your Honor. I think that's a factual question. Alachua County is pretty big, and if you don't have the means to travel and you live in the middle of the county, there aren't a lot of options, but that is certainly one of the factual questions that should have been analyzed in the restraint trade analysis. I see I'm out of time. I'd like to reserve a little bit for rebuttal if you don't mind.
Does anybody have any? Okay, then, yes, please.
Thank you.
Good morning. May it please the court. Natasha Mickens from the Delbury Law Firm, and I have the privilege of representing the school board appellate today. This court stated in 1990 in Medical Center Health Plan versus Brick, a party is bound by and a court is powerless to rewrite the clear and unambiguous terms of a voluntary contract. And
So what about the situation, they were involved in litigation, there were lawyers on both sides, and a deal had been worked out, and then at the end, you know, Ms. Banks was called into the HR director's office and signed a separate agreement as part of the underlying agreement with none of the lawyers there. Isn't that at least unusual?
Well, Your Honor, I'm definitely going to get into that today, and just quickly to come back to that, we have a contract here that has clear and unambiguous terms. So we don't get to look outside the four corners of this document to try and bring in some parole evidence of what people believe happened that day. And even so, if she was taken into the office.
But isn't that a problem for your client? The very thing you just said. We are bound by the four corners of this agreement, and what we just heard from the plaintiff's attorney is that there are things that are not captured in this complaint. There are things that are not in this agreement that are fact questions, potentially, or the types of things that need to be resolved on a summary judgment. So the argument you just made does not cut against your client's position here in front of us.
No, it does not, Your Honor, and there's a couple of reasons. One, with the meeting outside of the presence, there is no allegations anywhere on the record on appeal or in the briefs that she was under duress to sign it. She willingly signed it, and there's no allegations either that she couldn't have called her attorneys or that she couldn't have counseled with her attorneys. But to us, that's not what we would hear about today, because that's all outside of these four corners.
Well, it's the allegations form the basis of the unilateral mistake portion of the contract reformation, and they do raise questions of fact that may not be appropriate for a motion to dismiss proceeding. So why shouldn't we just send it back for summary judgment proceeding, where you can provide whatever evidence you have in the record that either this meeting never took place or there wasn't a unilateral mistake involved in signing of the contract?
And exactly that, the school board does not believe that this is a unilateral mistake. The school board does not even believe that this is a contract reformation issue. And also, we filed a motion to dismiss based on a number of arguments. The appellant has to overcome all of those before we can even talk about their causes of action. We had a motion to dismiss because of the plain language of the agreement. And today, that's exactly what I'd like to talk about. I'd like to talk about the plain language of the agreement. I'd like to talk about how the contract provision in the separation agreement that the appellant takes issue with, one sentence of it, is valid and enforceable. And also that this action is time barred by the statute of limitations. And then I would also like to address the fact that, appellant has brought these arguments of restraint of trade and contract reformation, and I would like to take the opportunity to respond to those.
What do you do with the fact that we have an initial complaint, a motion to dismiss the initial complaint, a dismissal with prejudice, not without prejudice, a dismissal with prejudice of the initial complaint, and we have precedent from our Supreme Court saying plaintiffs routinely should be given one opportunity to amend. What do you do with that?
Sure, Your Honor. And first, I know you asked the appellant if he filed a motion for leave to amend. There was none of that. It's on the record here. There's no motion for leave to amend. And even if he did, it's futile, because we have all of these other reasons why the trial court dismissed this action.
Let me ask you about that. He said there's no motion, and apparently there is no motion, but he receives in the mail a dismissal with prejudice of his complaint, a sentence or two, fairly cryptic. At that point, what would you have him to do? I mean, the proverbial ship has sailed. The complaint is dismissed with prejudice. I guess he could have moved for rehearing and asked for an amendment, but I mean, it's a little different than the normal circumstance where there's a dismissal without prejudice, allowing him to replead, and then we would be here after several attempts, and then you could make your futility argument. But I'm just having a little trouble understanding the first time, the first complaint, you're asking us to dispose of this forever, dispositive. You would agree that's a concern, would you not?
Your Honor, I wouldn't agree it's a concern. You asked in the beginning, what would I do? What I would do is probably not bring this, because I knew that I would have signed this 3-sentence separation agreement that says I cannot reapply with the school board. And I would have known that had I made that deal over 10 years ago, I would have to abide by that. So we wouldn't even make it to this stage. And even if we did, the trial court did dismiss with prejudice for all of the reasons that we had listed. So to us...
How do you know that? How do you know that? I mean, it's not in the order. I mean, it just says with prejudice.
Right.
Unless I missed the correct order.
No, Your Honor, no, Your Honor. And that's exactly our point of, we're here today because it was dismissed based on any of our arguments that we made. There are a number of arguments that we've made, both in our motion to dismiss and here in our brief that we filed with the court, as to why that dismissal should be upheld. There are all of these arguments that we believe that that is why it was.
Well, let's focus on one of those arguments, and that's the statute of limitations. I think your argument is that no matter how this case was pled, it would have been barred by the 5-year statute of limitations. But they have cited a case, the Corinthian case, that looks at the on-the-contract language and says that's not a contract reformation proceeding. And so how would you distinguish that case, or how would you persuade us that we should not follow the reasoning of that case?
And I'd like to point out a couple of things first before I address the case, and that's the timeline of this situation. Because the appellant signed this agreement in February 2008. And then, as the appellant said, in August 2015, they attempted to breach the contract that they signed in 2008 and reapply with the school board. That's still 7.5 years after she originally signed the agreement. And then she doesn't take any more concern with it until 2018.
Why is that relevant to my question about whether it's barred by the 5-year statute of limitation?
Because Dr. Pellant's arguments go towards the fact that, there's this tolling issue and she didn't discover the issue until 2000.
Now, I'm talking about the statutory language question that the 3rd District Court of Appeal, it's the 2nd District Court of Appeal looked at. On the contract, or a suit on the contract is not a contract reformation claim.
And in that case, they were talking about an agreement that was founded not on a written instrument, and that's not what we have here. And also in that case, they talked about different statutory provisions that the school board does not believe are even applicable in this situation. And that also goes to the fact that we don't believe that this is a contract reformation issue. The appellant trying to say that there was a contract reformation issue because of a unilateral mistake based on the inactual conduct and misrepresentation of the school board, that's just false. There are conclusory allegations as to that listed in that complaint and that brief, but that doesn't mean that it's real. And
that's not the burden at a motion to dismiss stage. The court has to take those allegations as true. Now, you might be able to disprove them, but how have they not met the burden at a motion to dismiss stage?
Because, Your Honor, we have this document that is, the one that they've taken issue with is the separation agreement. That is 1 page with 3 sentences on it. 3 very clear sentences, punctuated, capital letters. We don't need to look outside the 4 corners of that document. This is contract law. It's clear and unambiguous language. So we don't need to be looking at whatever else happened in a different room or anything like that, when we literally have this document that lays everything out for us.
Well, I hear you, and normally that's what happens, but based on the pleading here, they're saying some bad things went on outside of this document, and you're saying it would never be a plaintiff's right to make a claim outside the 4 corners of an unambiguous document, no matter what may have caused the signing of that document? Is that what you're telling us?
No, Your Honor, and this is an unambiguous document, and if they allege something else, maybe that would be a different story. But like I said before, we still have the motion to dismiss based on all of these other arguments that they have to overcome. So trying to bring in this inactual conduct, it's not relevant to this situation because we have this contract.
Well, it potentially, on a motion to dismiss, may be relevant as to your point that this contract is not ambiguous. I hear you that we've still got to deal with the statute of limitations and some other points your client makes, but it would certainly, you would agree, if we have to assume that to be true, that this happened in the way they claim it did happen, that would be enough to get it past the motion to dismiss stage as far as the 4 corners of this agreement. Would you know?
I disagree slightly, Your Honor. And in Mogens v. Dreyfus, which was a 1999 11th Circuit Court case, applying Florida contract law principles, the court stated that when negotiating or attempting to compromise an existing controversy, as the appellant attempts here, it is unreasonable to rely on the representations made by others. And we cited case law about this whole idea that you cannot rely on representation of others when you have a contract like this. There's also a case cited by the appellant, Camichos versus Diana Stores, which was the Florida Supreme Court case from 1946, where it said that the language in the paragraph that they took issue with in that case was plain and unambiguous, and the court did not have the court would not write a new contract for the parties.
Well, there's an extra twist here, because there's an allegation that there's been a violation of Chapter 447, which I'm very familiar with, which involves that the allegation is the HR director had these conversations outside the presence of the union representative. So does that not make this a different case than the ones that you have cited?
And I don't think it does, Your Honor. I think for a number of reasons. Again, going back to, not to be repetitive, but we do have all of these other reasons why we have,
Well, if we disagree with you, let's just assume
Okay.
for purposes of our questions, we disagreed with you on all those other reasons, and we're really left to look at whether there's a sufficiently pled cause of action.
Okay, Your Honor. And to that point, we don't think there is a sufficiently pled cause of action here, because the two that the appellant tries to make, a contract reformation and restraint of trade, neither of which the school board believes are applicable in this case.
Well, let me follow up on that. Assume it's your position, and you may be correct. It's not sufficiently pleaded. Why don't they get another chance to plead it correctly? Help me understand why this is only a one-time event, when in most every other case, you get another chance. Explain to the court why they only get one chance here.
Sure, Your Honor. And again, not to be repetitive, but like we said, there were all these other reasons that we had the dismissal of at the trial court level. And with his causes of actions, we have to overcome all of those arguments that we made down in the trial court first and in our brief. But also because contract reformation and restraint of trade are not applicable in this situation, especially with restraint of trade. The appellant tries to say that the agreement restrained the appellant from engaging in her profession as a teacher in Alachua County. But that's completely not true. And as Your Honor's pointed out earlier, she could work as a tutor, she could work at any and all private schools within Alachua County or outside of Alachua County. She could work at any and all public charter schools in or outside of Alachua County. She could work at online schools, like Florida Virtual School, which you could do from your home within Alachua County. And that doesn't include the other 66 counties we have here in Florida. That she'd work at any and all of those schools. So trying to say that the school board has restrained her profession, it's an improper argument to make before this court. And with appellant, they talked about Golden versus California Emergency Physicians. That case was all the way out in California, and it was completely different to the facts that we have here in this case. In Golden,
This in California is a Ninth Circuit case, correct?
Yes, Your
Court
Honor.
of Appeals, Federal Court of Appeals?
Ninth Circuit, yes, Your Honor.
Okay.
And in Golden, and I bring this up because this was the linchpin case that the appellant relied on for their restraint of trade argument. And Golden was an employee throughout the huge state of California. We're talking about the school board of Alachua County. And in that case, they said that they had plans to expand the school board of Alachua County, unless Alachua County magically extends its borders. The school board has no plans to extend. So it's completely...
These all sound like factual questions to me. I mean, what employment opportunities are available to a particular person in a particular county in Florida? I mean, we can speculate on that, but I don't know that it's a factual matter. So again, why is this an appropriate argument that you're making for a motion to dismiss analysis?
And Your Honor, I see I'm running out of time as well, and a couple of points I would like to address. It's important because you can't have a linchpin case that you're hinging your entire argument on when there's completely different facts and from a completely different circuit. And if I may just have 1 minute to just wrap up.
Please.
Thank you. Essentially, in this case, the appellant is wanting this court to ignore the plain language of the voluntary negotiated settlement agreement that they entered into, to ignore long-standing precedent and invalidate an entire negotiated settlement agreement for over 10 years ago, to endlessly extend the statute of limitations or just completely disregard the statute of limitations in this case. And finally, they want you to make new law on contract reformation or restraint of trade, which, as I said here, are completely inapplicable. So for all of these reasons, the school board respectfully requests that you uphold and affirm the trial court's dismissal. Thank you, Your Honor.
CJA cases have said that, the other cases have all said that, the NOAC case said that when you have a contract reformation based on unilateral mistake, cruel evidence does not bar that claim. That's very clear. Second, the plain language defense also does not apply to either of these causes of action. Plain language is exactly what contract reformation is to change. You have language in a contract, and you have, for some reason, in this case, inequitable conduct that requires that language to be changed, and the court, in a reformation action by definition, changes the language of the contract. The Goodall case talks about how the language is often obvious. And again, in those cases, in NOAC and in Goodall, more than this contract, there were integration clauses, there were merger clauses, and there were sophisticated parties represented by counsel. In a couple of these cases, I think there were like millions of dollars at stake, and this court allowed those claims to proceed, notwithstanding the plain language of the contract. Plain language is also not a defense to a restraint of trade.
Well, I do want to ask you a question about your restraint of trade count. It's my understanding that we're to look at case law construing the Sherman Antitrust Act, and that case law requires concerted action. And have there been any allegation that there is concerted action here in restraint of trade?
I don't know that that's a requirement of the cause of action to show that. There is an allegation in the complaint that the school board maintains a no rehire list, sort of a blacklist, and that other counties look at that list. It's visible in some way, which prevents Ms. Banks from it, which I think the complaint says adversely impacts Ms. Banks' ability to be hired in other counties. So there is an allegation that this impacts her ability to get hired in other counties.
And is that what we're supposed to look at for restraint of trade analysis, the impact on one individual, or are we supposed to look more broadly to see if there's an impact on an industry?
No, I don't think that the restraint of trade law is very robust. I don't think that there's a lot of instruction, but I mean, looking at the cases myself, it looks like it is a factual analysis that you look at how burdensome is the restraint, which involves lots of factual questions. What jobs exist? What are you able to do? And involves the employer's need for the restraint, which, again, we don't have any evidence that the school board of Alachua County is in some critical need of preventing a little old woman from ever even applying to work in the district. They don't have to hire her, but why does she not even be able to get to apply and come in the door, initiate a conversation that might lead to a principal saying, hey, I want to hire you, and then having a conversation with the attorney, hey, can we renegotiate this agreement? So I don't, but these are the kinds of factual questions that I think we should have had a right to pursue and explore with discovery.
Mr.
I
Lynch,
see
you're
I'm-
well past your time.
I see I'm way over. I thought it was ticking down. It's
No,
ticking over.
you're past.
I see I'm way over. I apologize. I'll sit down.
Thank you
Thank
very
you.
much. Thank you, counsel, both for your arguments.